not been contested. If they want to go to court over that boundary and a survey done, now they both have surveys and they conflict now. So, you're talking about something that we have no resolution to. There's no definitive survey that says that she's encroaching. I'm not going to say she's encroaching. Be careful when you do.
Mr. Mitchell?
We saw a survey, and we said that half of the street's missing. My question is, how come we're not pursuing it? You have mentioned before, and it's a very good principle and one that we seem to be following with other issues, but we talk about equity and fairness. And I'm considering equity and fairness here, and I see a resemblance between what we're doing with McClung and Hartman Street and what's going on with Rock Street. And I also see 7, 8 accesses, 2,000 foot of frontage, and so a lousy little piece of Rock Street that goes within 6 foot of somebody's house, I really question it is in the best interest of this city and this council to not grant the vacate.
Mr. Purkeypile.
I was going to say we were kind of getting off track here. We need to get back to just Rock Street discussion.
Parks Director?
I think one of the questions that, and I'm a little confused because as the Director of Parks, the only thing that I know about or care to know about there is what's green. That's an open street. These are streets that are vacated. This is the only access that the city owns. The city has a right of way to that. It runs from here, and I'm going to turn this over to Cheryl. But it runs to here, it runs to here, and it runs all the way out to Hart's Grocery. This is the only city access. If anybody's riding or having a trail on Marble Flats property, that's private property. That's not mine. That's not something that I have anything to do with. I don't want to say that's trespassing. There must be some kind of assumed agreement somewhere, but that's not my business, and that's not the city's business either. Clear? These are streets that are owned and controlled by the city that we call greenways, green spaces. And that's all that we can be concerned with, in my opinion. Anything else is private property. If you look at these yellows, the reason why we're here tonight is because we did all this. We wouldn't have this discussion if we hadn't wantonly vacated. And here we step again into that same trap. Let's vacate. We have other ways. Well, did we say that when we vacated that? We vacated that. We vacated that. We vacated that. We vacated that. We get the point. We've made these mistakes in the past. Let's not make them again. This is Cheryl Willis.
Yes, I'll reiterate that. We wouldn't be here today if we had not vacated some of the most prime property in Eureka Springs. And we sit here tonight hearing more vacations before we have a plan done. That very much concerns me, and it should concern you too, because you're talking about equity and fairness. The city council is here to do their job for the support of the entire community. We're not talking about her versus McClung. We're not talking about us versus her. We're talking about, are we taking away valuable property from the citizens of this city that you are sworn to care for and protect and to provide for? And yes, we did this before. Someone did this before. I sure didn't. I would love to have said, let's make this the primary trail through town. And that would have been so much easier, so much more wonderful. But it's gone, it's done. And it doesn't matter if there's 1 million people walking there, that's private. And they can charge for that if they want to. Or they can say, get off my property at any moment. But they can't do that to us here because this is ours. Now, it may need to be surveyed. We may need to go. I have found some stakes. I have stopped and talked today, just today, to several people who are so on board with this. And one of those is the art colony. It is not just good for the people of Eureka, it's good for business. I've talked to the principal of the high school. I've talked to the superintendent's office. I've talked to First National Bank of Berryville. All of them are ready and willing and able, and Rapid Roberts, to say, we want this, and we will help you. East Lab has been committed to us. The high school students are willing and able, and the principal said, they're yours.
Excuse me, just a point of order here. Are you talking specifically about that piece of property, or are you talking about a large picture of trails throughout the city? We are discussing.
Okay, we'll
that
talk about
particular
Rock Street.
part.
This
Yeah,
particular
let's keep our
part
conversation
is
to
connected
that.
to the entire part of Rock Street. So yes, the artist colony is very much a part of that. And I talked to 5 people there tonight who said, we want it, we're ready. And they want to be able to walk there. They know it's there.
I have another point of order here.
Okay,
Yeah.
point of order.
Would you point with your pen to that small piece of Rock Street that we are discussing
We're
tonight?
talking about right here.
That piece of Rock Street.
Right
Okay.
here. And it is absolutely critical to the plan of the Trails Committee making trails through town. And this is the backbone. We can't do the other trails and get all the way around without this piece right now. If you take this, we're dead in the water.
All the way around to what?
I can't.
I'm
basic
looking at- no,
image.
show me the green
Okay.
thing here. That's
Okay,
the
so
Rock Street.
right
Where
now
are you
we
gonna
would
go
take
there?
this and we would have to cross the street and come here.
Now, where are you going to go if you enter the property, the Brix's property, and you're standing there and you're going to go up that hill? Now, where are you going to go from there?
From here?
Show me the trail.
You're talking about here. Okay, let me restate that it is not the Briggs' property, it is city property.
Okay, that piece of city property.
Yes,
where
that
are
piece
you
of city
going to
property, and we will go up here and on Rock Street all the way down, cross Mill Street, and go on to Vine Street, and go on Vine Street down. This is the city map, but I'm assuming we're going here. I have my maps drawn differently here. And basically down here through Water Street on all the way to Harts. That is possible, doable right now on city property. We have the right-of-way. If you take this, because we can no longer do this, if you take this, we get here and we stop. And we have plans to be able to go all the way from here, all the way to Harmon Park, all the way to Lake Leatherwood, all the way down to Bass Lake, Black Bass Dam, all the way up. I am getting... Right, okay.
We have a lengthy
Okay,
agenda
this is
tonight,
crucial.
so you
This
have made your
would be
point.
like cutting off part of 23 and saying the semis can come here and then they can't go any farther.
Thank you very much.
Point of order.
Mr. Mitchell.
Yes, let me walk up, leave that up there, please, so I can be very clear, Mr. Levine. I want to be very clear. Brix's property right here,
Is right here
on
on both sides.
this easement right here, that goes through right here that matches up with this yellow. This could easily turn, go here and join here. It doesn't have to go this way, it can go across.
That'd be fine.
But it would.
We believe, but we don't know. But I'm pointing out, here's another one here, and likewise, there's another one right over here that comes to that lady's property where the old building is. There it is right there.
That's vacated.
So that one, they did vacate that one, okay. So here's one right here, though.
That dumps us off onto Highway 23
Nope.
instead of.
Look, that would be fine. As far as I know, that's vacated. That would be wonderful.
Okay, Mr. Purkeypile.
To address that alley that you showed right there, that is vacated. That is Pat
We know it.
Lujan's. Yes.
We
that's
know it
Pat.
100% that the city vacated it because it shows up in his deed.
Yes, he will. You'll have to ask him
Okay.
for that proof, but that has
But
been
it's there
vacated.
and it doesn't show, but okay.
The question tonight is, in my mind, and I'm taking all the personality out of it, I'm just saying, if you were sitting in that house and you had somebody said, listen, we're going to build a street here. We got a street that comes within 4 or 6 feet of your front door, and by golly, we're going to put it right here, even though we have an unstable cliff and hillside that we're building it on, it's too steep for an approach, although we have very steep roads in Eureka Springs. There's no visibility for a car coming up over that. Therefore, its only truly good use is as a driveway for that property, because those people will know who's coming up their driveway. When you utilize it as and insist that it is a 30-foot wide easement for a roadway, firstly, I don't think you can do that. There's not enough room to actually do that. And would it be a 2-lane road or one-way? Well, we don't know. So my point is, realistically, it's not a good access point because it is constrained by property that has been there and been constructed with no other plans ever laid out to construct a roadway through there, ever.
Can I speak to that?
No. You can get elected to council and then you can speak. But at this point in time, it's not a good location. There are other locations that are good. Now, it's going to come down to the legal aspect of this, and if the city comes down to the point, and I see our legal consultant has his hand up and will address a point or two. I still think we really realistically, taking all the personality out of the issue, we really can't justify building a street there, because the street would have to be built by the city. No?
Okay, let me have the city attorney. Yeah, go ahead.
If we grant that there is something there, and has been there for many years, they were on notice when they purchased their property, okay, that there was something there. They've never been able to show, and they were given an opportunity by council to bring me something to show me that the city did not own that. And I did not receive anything that conclusively says the city does not own that access. So that is an access point of the city and of the adjoining property owners, Marble Flats. Whether or not they have 500 other access points, the state law in Arkansas has been, and the Municipal League has cautioned repeatedly the cities, if you take away even a small access, you are subject to damages for that diminished access. Okay? Whatever that is. How is that decided? Do we offer them $10 for their diminished access and they have to take it? No. They can go to a court of law in this state and get a jury who can say that that access is worth $1 million. And then we have to appeal that and try to get that reversed. They don't normally reverse on appeal. Now, I don't think any jury in their right mind is going to give them $1 million. Not saying that. But we have no idea what a jury might say in this town. Several years ago, the city tried to buy a small piece of property here behind the courthouse that we needed supposedly to build public facilities for the police department. When we were sued, the estimates that the city had been given of what that property would be worth, when we tried to condemn the property, come in at a much, much lower amount than what a jury of the citizens of this town, primarily, some drawn from Holiday Island because they're drawn from the Western District, more than doubled the amount that was going to cost the city if they had proceeded with that taking. If we are making a taking of that access, we are running the risk of the city at that point cutting off something that is a right of someone else who then has to be compensated for. We also have your Parks Department, who is repeatedly telling you that's an access that they need for their trail system.
Mr. Mitchell.
I would like to remind council of something very important. This council requested at a meeting that you get with Mrs. Briggs and that you get the information that she had about that the city didn't own it. And instead, you came back to this council, having talked to 2 council members and never researching the point that she made that we actually asked you to do in the... I'm going to finish.
I'll let you finish. I'm not...
In the first place, and you never came back and did that for us, because that was our specific question to you, to find out, was her question, did we own, did we not own that property or not? And you didn't do that. Instead, you come back and said the 2 councils. I also find it interesting somehow that you bring up these points, which are very valid, probably very valid there, but I think those points apply to other things that we vacated, and I don't hear that from you. The city, every time we turn around, is going to get sued, but we do have the right to vacate, and council does have the right to vacate, and yet we never get too excited on other things. When everybody goes, oh God, we're going to sue, and it just seems to be inequitably applied to this situation, and I'm kind of concerned about that.
If I may.
I'd like to, since I still have the floor, I'd like to let Mr. The attorney, Bishop.
I'll
Since I still have the
recognize
floor.
Matt Bishop.
Thank you. Just a couple of brief thoughts. One is, I've noticed on this, we're beginning, we actually do have a public walkway all the way down Main Street with sidewalks, just a few feet away. The other is, we've talked about takings. Takings only apply for an abutting property owner, and I know Mr. Williams will disagree with me on this, but there is an alley separating. This is not Rock Street. This is not on the original plat. This is on a separate subdivided plat, so this is technically not Rock Street. It's just, at best, it's an unnamed street, which may or may not be owned by the city. However, there is an alleyway right here, which you are not being asked to vacate. That means that Marble Flats is not abutting, thus Marble Flats cannot claim a taking. I expect Mr. Williams, who is smiling at me now, to vehemently disagree, but so that you don't automatically get sued. He has some hurdles to jump through to get to that. So I think before you get too deep into the weeds of the legalities and worrying about getting sued, the better question is, does this make sense for your citizens? And that's where I would start before I got too far in. And it reminds me a little bit of the old thing about a conservationist, somebody with a house in the woods, and a developer, somebody who wants to put one there. And I think people are very generous with other people's property, is what it seems like.
Mr. Williams, would you like to address that?
I would. Thank you. Just to specifically address that particular point, the alley in question that was pointed out that's not being requested to be vacated already is vacated, and the properties do adjoin. Irregardless of that particular question, and that's something that can be litigated in the future, I think that the case law in Arkansas is pretty clear that an affected property owner has the right to access. I actually wrote 3 pages of notes to talk about today, and I'm not going to burden you with those things because a lot of it gets into the history of how we're here. There are a couple things that I feel specifically need to be addressed, one of which is the implication that someone has kept information from the council that there are other access points. No one's ever questioned whether or not there were other access points. It's very clear to anybody that wants to look at the map that we had earlier that magnetic runs along the side of this property. The issue is not Marble Flats access. That's never been the issue before Parks, Planning, or this council. The issue is whether or not it's in the public interest, just as Mr. Bishop pointed out, to vacate the street. When you start talking about whether it's in the public interest, it might be important to look at the standard that you're actually supposed to be applying. It's easy to get impassioned. It's easy to think about your neighbors and the way something may specifically affect them in a particular instance. But as elected council members, you still have a job to do that requires you to take the passion out of it. Specifically, Arkansas Code Annotated 14-301-303 states, at the hearing after the petition has been filed and we've gone through the process, it says at the meeting of the council as designated in the notice, any property owner affected by the petition shall be heard. So first of all, that gives everybody the right to speak. It says then the council shall then determine whether, from the standpoint of public interest and welfare, the street and alley should be vacated as proposed in the petition. There's been talk about all the adjacent property owners have agreed to it. Assuming for the moment that Mr. Bishop is right and that Marble Flats is not an adjacent property owner, all that does is create a prerequisite to the council even considering the petition. If they haven't all agreed, you can't even consider it. Every affected property owner gets to be heard, and that's why I'm here today. But the standard that this council has to apply is very, very clear. It's not, does this adversely impact Mr. and Ms. Briggs? It's not, is this something that the equities ought to let us do for them? It's not, should they be burdened with a trail or a street in front of their house? It's, does vacating this street is it in the public interest and for the public welfare? It's very clear. There's been one item that I think I need to specifically address, and for that, I actually have some information for you. What I'm handing you is a copy for everybody of the deed where Mr. and Ms. Briggs took title to the property. Then, with your indulgence, I'm going to also hand you a copy of a survey from 2009 prior to their purchase that was compiled by Arlie Weems, or for him. Arlie Weems was the seller to Mr. and Ms. Briggs. What I've done on that survey is I've highlighted what their legal description actually describes. It's been stated repeatedly, including in the application for vacation of this street, that Mr. and Ms. Briggs own the street. I'm here to tell you that based on their deed, unless there's another deed that's been filed since then, they don't own the street. They own the lots on both sides of the street, but they don't own the street. They do not have title to it. It was never deeded to them. And I'll be glad to walk anybody through that legal description that wants to take the time to do it, but I don't think it's probably appropriate for me to do here this evening, unless the council so wishes. The street itself, there's been arguments in the past. We don't know where Rock Street is. The surveyor will tell me we don't know where it's at. He's not sure that he surveyed it right. Well, the surveyor's not here to tell us that. What I can tell you is that back in the 1800s, a survey and a plat of a subdivision was created and filed. It created Rock Street, an unnamed alley, whatever you want to call it. And when that plat was filed, following that plat, lots began to be sold out of that subdivision. The legal description in front of you that was given to Mr. and Ms. Briggs uses those lot descriptions, describes each of those as a lot and a block in that subdivision. The law in Arkansas has been settled for over 100 years with regard to this issue. And it specifically states that it's a well-established principle of law that an owner of land, by laying out a town upon it, platting it into blocks and lots, intersected by streets, and selling lots by reference to the plat, dedicates the street to public use. At the same time, I'll tell you this, whether the argument that there's a right-of-way across it, the city owns it, whatever the argument is that is made, the process is the same. And the process is set out in your ordinances, and more specifically in Arkansas Code, 14-301, 301 at sequence, okay? And that requires the standard that you apply be very specific. Is it for the public interest? Yes, sir.
Mr. Purkeypile.
Well, okay, and I agree. Is it for the public interest? And I think the Brickses are part of the public, the body of the public polity. I guess the question I need to ask you, if you're representing Marble Flats,
Yes.
Could you come forward to the microphone, please, sir?
Yes, sir.
To your knowledge, Wade, does Marble Flats plan to construct a road there?
I don't have any specific knowledge as to their plans. To my assumed knowledge, they don't have any plans to do anything in the next immediate future. I think that from an access point, it is important. I think from a utility point, just by looking at the property, that it's a critical point of contact. It is the downhill side that's going to be the closest to the sewer. So I think from utilities, it's very important.
But to your knowledge, there is no plan. There's no plan to develop Marble Flats. Is Marble Flats and Partners, are they actively pursuing the sales of the property?
Those are both questions that you'd need to direct to them. Again, they could have an engineer working on plans as we speak, and I might not be apprised of that. I'm not aware of any such plans, but I cannot eliminate that as a possibility.
Let's have the city attorney.
I need to address something that you said a moment ago, Mr. Mitchell, and I don't want you to take this as a personal attack. This council directed me to take certain actions. Those actions were to find out and answer a question. Both parties in this instance are represented by counsel. In Arkansas, the laws are very specific in the rules under which all attorneys act. And it is at the peril of their license if they act differently, is that if the council approaches a representative party, they must do so through their representative, through their legal counsel. And that's what I did. No matter what this table directs me to do, I cannot have direct contact with a representative party without going through their counsel. And that's what I intend to always abide by.
Okay.
And so to state that I didn't do what you asked, I believe I fully fulfilled my duty to this table. And I believe I also fully fulfilled my oath that I swore 22 years ago before the Supreme Court of this state, that I would fully act in accordance with the rules of professional conduct, which are placed on this attorney, and myself when we swear in and become members of the bar of this state.
Okay, I'm going to allow one more round from the table. I'll allow Ms. Bricks to address council. Then I'm going to request some action from council. So you're going to have one last bite at the apple here. Ms. Zeller.
Well, I haven't spoken yet, so. Okay, it's pretty clearly stated that this is not about the Park District. That is not about, we're not debating here whether the Park District should have a trail or not. According to the Park District's map, it looks to me like they're going to have trails all over the place. And when you make an extreme statement like to me, like the entire future of the trails program depends on their having access to put a trail in the street, I kind of back off from that. I'm sorry, people. That's a little bit extreme for me. Now then, they have already said that they evaluate, the Parks has already said that they're not interested in things that have never been used, that are not workable, and that they don't connect really to anything. And that pretty much describes Rock Street. The question is, the city, I assume, owns the street and has the right to vacate it if we want to. Now then, is it in the best interests of the city and the public to do this? I agree with Councilman Purkeypile that the notion of building a road on there is just not doable. He's an engineer, so I'll follow his lead on this, but my common sense tells me that you're not going to be able to build a road without blasting through that rock, and that's against the law in the city of Eureka Springs. The expense of it would be absolutely horrendous, and I doubt whether a utility company is going to want to go up that road to bring utilities to Marble Flats when they have Magnetic Springs as an access. Now then where does the public interest come in at? If we vacate this, the Bricks want to develop this property. They want to put another building there. They want to make it an income-producing property. That will put it on the tax rolls. It will bring revenue to the city, and it will put to use a piece of property that is not going to be used for anything. And I had no idea that the parks trails were accessible to motorized vehicles. The thought of motorized vehicles running up and down that road would give me the shivers anyhow. Then that road, the only thing that's going to get up that road is a motorized vehicle. Anyhow, I think it is in the best interest of the city to vacate this property and to allow it to be put back on the tax rolls so that we get some income from it, and so it becomes valuable. to somebody and it becomes income producing. I think the Parks has all the land that they need to make trails. I don't think the Marble Flats people ever intended to build a road here. I think when they bought that property, they knew there were no easements, and they had a realtor dealing with them, and if they ever intended to use that street as an access, they would have gotten an easement from Harley Weems, and they didn't. They lost their opportunity. That was brought up here at the table tonight. That's when they should have. But they wanted to build a road there or have access. That's when they should have done it. They should have gotten an easement, and they knew that there weren't any. So as far as I'm concerned, we should vote at this table tonight to vacate that property and be done with this. We have put hours and hours on it, and it's beginning to look to me like it's just a bunch of guys that are trying to bully the bricks just because they can do it, because we have been asking them to tell us why they desperately needed that piece of property and what its value was, and nobody has ever given me an answer. They haven't given David an answer. They just want it because they can. And that doesn't, I'm sorry, that doesn't strike me as fair. I think they're just being bullies. And that's my opinion, and if it comes up tonight, I'm going to vote to vacate.
Mr. Mitchell.
It's very hard to follow Joyce because I obviously agree with her, but I'm going to go back and make one point, and that's specifically to the attorney, and then I'm going to finish. We ask you on the principle, did the city own or did the city not own the property? So everything you just told me a while ago about all your ethics you have to do with two attorneys is absolutely fine. Nobody's going to disagree with that, and nobody would ever want you to break it. But when you came back from the consultation with those attorneys, you still never answered that question. That's what I want to point out to you. You've never said yet to date that what was raised by the Brickses and you discussed with their attorneys was or was not a fact. You have never said, does the city own or not own that property, even with consultation with them. And I am going to vote tonight to vacate that property.
Mr. McClung.
Well, it's just a real mess. Unfortunately, it's a real mess. But, you know, I have to be very plain spoken here, and I just really have to be. And I'm sorry, Joyce, but what you said didn't make a whole lot of sense to me. It just really didn't. And David, when Mr. Weaver came back to us, he did. He told us that he had spoke to both attorneys and that he thought the city controlled the street. He told us that at that meeting, very plainly. And it may not be in the minutes, but he most certainly did. Watch the video. He most certainly did. And most importantly is the fact that Mr. Williams brought up by state statute. It is in the best interest of the citizens. And when you got somebody else that has that access and has that right, you have no right, we have no right to cut them off. I don't care what they have. We don't have it. I don't have that power. They got as much right to it as Joe Blow down the street. No offense. I hate it for them because it hurts. But you know what? That's the way it is. Sorry.
Mr. Purkeypile. Any thoughts?
Any final gestures here? Well, in my mind, I just find it unusual. I've asked the Marble Flats guys, why, had they sought to work with the Brickses regarding access in terms of providing, and especially if access with this road, it's just too close to a house for safety. You have to come up a very steep incline at a high rate of speed to get up the road currently right now, and it should be improved. So it realistically, it would need to be moved, and then you'd get into all sorts of things about getting an easement from the Brickses, and then at least backing the road away from their house. So I haven't heard anything from Marble Flats per se that discussed any of the methods that might be used to come to a compromise. Such that we don't have this combative issue that we have right now. And I would like to, Mr. Williams would like to speak,
Yes,
briefly.
I'm going to give Mr. Williams an opportunity to speak, and then y'all need to decide who's going to be the last voice on this side. Mr. Williams.
Thank you. Appreciate the chance to address that specific question. We've been here numerous times, as everybody's aware. Repeatedly, this table or the Planning Commission or even Parks has said, would you guys be willing to compromise, speaking of Marble Flats? I've stated in every public meeting where that question has been raised. I've stated privately to Ms. Briggs, to her counsel. We stated privately and publicly to her predecessor in title, Arlie Weems. We're willing to listen to any offer. We're willing to listen to any proposal. We have not once been approached. The only meeting that ever took place down on the property. Matt Bishop was there representing Arlie Weems. Arlie Weems didn't show. But all the representatives of Marble Flats were there willing to listen and look and see if they could come up with a solution. But in response to that, it's not really Marble Flats' place to have to come up with a solution for a proposal by Mr. and Ms. Briggs. The burden really needs to be on them to approach with some other reasonable solution. They're the ones asking for the city to vacate the street. Marble Flats, and I'll state it again, I'll give anybody that wants it my cell phone number. We're willing to talk and listen to whatever they want to propose. I want to state just a couple of things about what Joyce had to say. Specifically, I don't appreciate being accused of being a bully. Okay? I've been to each meeting. We've tried to be reasonable. We've tried to be accommodating. We've made ourselves available for any reasonable proposal. Not once have we been bullying. We've never been approached, but we've always been willing. In answer to the question of why we didn't seek an easement, no easement was needed because there is a city street. It's platted. It exists. No easement needed to be sought across Arlie Weems or Rachel and Ryan Briggs. Their deed does not include the road in question. It specifically has a gap for it. You asked about what is the urgency now. Well, the urgency now is that there's a petition to vacate. So we're here addressing it and defending it, and we'll pursue our remedies in the event that the city elects to vacate. You then stated Marble Flats knew of this problem when they bought the property. They knew there wasn't an easement. Well, again, no easement was needed because there was a city street. But that same statement applies 100% to Mr. and Ms. Briggs. They knew about it. When we go to trial, we'll be presenting evidence that not only did they know about it, that they specifically acquiesced to it. That survey was of record. I anticipate that we'll be able to produce a copy of that where they signed it at the closing table, acknowledging that they were aware of that survey. All of that stated, this council is required to follow its procedure. I would encourage you as council members to look very closely at the procedure you are following, because I guarantee you, depending on what action you guys take, either myself or Mr. Bishop is going to be looking at it really closely.
Final comments?
Please, thank you very much. There's been so much said, I will be brief. Thank you very much for the opportunity. As far as deeds, you know that it splits directly through the middle of our property. There was no acknowledgement on our deed whatsoever that that easement existed. There is no acknowledgement of that deed. It says, like it's a blanket statement on every deed, like subject to rights and easements of record or something. That's on everyone's. Nor is it a viable access printed on Marble Flats' deeds. As far as vacating, city has an option to vacate under 1454-104. That's what we're asking you to vacate under this evening, not 14-301-301, where everyone has to sign off on it. We know that's not possible because we know we have a neighbor in disagreement. As far as the public interest, it's even been said at this table, how does private property come into public interest? This property has been privately owned for a very, very, very long time. The city has never even owned it. The city has obviously roads through there and alleys through there, but the city's never owned the property, so I don't understand where public interest comes into private property. Also, there's never been anything there in over 100 years. If there were public interest in that property, something would have been done with it by now. As a matter of fact, all 3 utility companies signed off on not being interested at all in putting utilities up through our property just in May of last year. SWEPCO, Source Gas, and even Dwayne over at Public Works checked the box where it says supports the vacation and said no utilities in the area. Now, I know this is a swear word right now, but eminent domain, if that's the access that ends up needing to be used for Marble Flats, if that's who the developer, the engineer, whoever buys that property, if they want to put utilities there, eminent domain could probably also possibly be an option. The city has no documented plans for this area. They don't now, and they haven't had documented plans for this area. And Marble Flats has not put forth any plans for this area. So as far as public interest, there's been nothing going on there for a very, very, very long time. In addition, as far as compromising and as far as the bullying comment, I went to Mr. Bland to his office when we first moved in July of 2012. He laughed at me. He said, "Yeah, part of it goes through your sidewalk, doesn't it?" Yes, it does. They're not interested in vacating. I then went to Mr. Wolfenbarger and asked him about possibly trying to come to some resolution or something. Nothing was come to. I have gone to them. They don't even have plans for property or anything. We went to them. The only time they came to us was when they came to our property and stood in our driveway for 8 or 10 minutes before the last planning meeting telling us how opposed they were to all of this. And that was Mr. Bland and Mr. Bunch. So, I mean, as far as trying to work with them, we have tried. We have initiated actually contact with these folks. And I think that's all I have to say. Thank you.
Thank you. At this point, if there's no motion from council, we'll move on.
I'd like to make a motion that we assign a number to the reclaim ordinance that's before us and read it tonight.
I'll second that.
Discussion? There's no discussion. Oh, I'm sorry.
Mr. Attorney, what are the, if we go through with this tonight, of course this is just to reclaim it, but what are the, in your opinion, is the repercussion to the city, adverse repercussion to the city?
As to reclaiming it, at this point I see none.
Okay.
As to acting upon it once it's reclaimed, that would depend on what action this council decided to take as to what repercussion that would have. Vacating it potentially could have the result of the city being sued if it.
Okay. Thank you, sir.
Okay. If there's no further comments, then all in favor of the motion of assigning this ordinance a number and place it on its first reading, all in favor say aye.
Aye.
I'll vote aye on this. Opposed?
No.
Okay.
Mr. Chair, I'd like to make a motion to suspend the rules and play. Oh, I'm sorry. No, after you. I'm
have to do
sorry.
this
You have to read it. I apologize.
The ordinance number will be 2207.
I'm sorry, 2207?
Yes. An ordinance reclaiming authority over an unnamed, unopened street located between Block 1 and Block 2 of the Magnetic Bay Survey as platted on the Riley and Armstrong plat of 1893, Carroll County, Arkansas, from the Parks Commission's authority previously granted over green space within the city of Eureka Springs, Arkansas. Whereas the City Council previously placed green space within the city under the authority of the Parks Commission, and whereas the City Council now desires to possibly dispose of an unnamed, unopened street more particularly described herein, and whereas the Parks Commission and the Planning Commission have been consulted, now therefore be it ordained by the City Council of the City of Eureka Springs, Arkansas, Section 1, that the following described property is removed from the authority of the Parks Commission as it has been previously granted over green space within the city. An unnamed 30-foot wide street beginning at the southeastern corner of Lot 3, Block 2, and the southwestern corner of Lot 19 of Block 1, ending at the northeastern corner of Lot 1 of Block 2 and the northeastern corner of Lot 15, Block 1, all in Magnetic Bay's survey as platted on the Riley and Armstrong plat of 1893, situated in the northwest quarter of the southeast quarter of Section 10, Township 20, Range 26, in Carroll County, Arkansas. Section 2, repeal clause, all ordinances, resolutions, and parts thereof in conflict herewith are hereby repealed to the extent of such conflict.
I'm looking for a motion to approve Ordinance 2207
So
on its
moved.
first reading.
Second.
Okay, we're in discussion. I'll just state that if council moves to suspend the rules, I will vote in the negative on that motion. I feel that we've been this far down the road. I don't see where expediency is what we're after tonight. So a studied and scholarly approach to this is what I'm advocating. So that's my comments. Mr. Mitchell.
I take that as I take that negatively. That bothers me that you would make a statement like that, because if we suspended the rules and moved it on, we could move right up to the vacate, which seems to be the most important. Reclaim isn't a time to necessarily do anything. We're just reclaiming it from parks. But the real issue is the vacate. And I take exception to what you just said. I find it offensive.
There was no offense intended, Mr. Mitchell. Voting for the majority here was, in my opinion, allowing this to go forward because there is some gray area here. And hopefully the councils will be able to provide more insight into this. We've spent a lot of time on this, and I don't know what the hurry is. And that's my feelings on this. So I voted for this because I don't want it to end tonight. And I think things like this, take a little time. I'm not completely sure how I feel about this, and that's why I said I don't want to rush this. So, that's my feelings, and I have to stay with that, Mr. Mitchell.
It's we're in discussion, and that's fine. I appreciate your feelings, but going through reclamation isn't anything we haven't done for other people at the same time. It moves it to the issue of vacating, which is where the discussion becomes most important, and that's the issue. So I still disagree with your statement, but I'm not going to make that motion in deference to you. And we'll just let this go along and continue all this and have all these discussions. That's fine, but I still take exception to what you said.
Well, my feelings in this is that there may be a potential compromise here. Listening to Mr. Williams, utilities seem to be paramount in his approach on this. I don't know how the Bricks feel about that. So, the attorneys can discuss this. Maybe they can come to a decision. Council has made an action tonight. So I think that speaks loud to all parties involved. Beyond that, I can't speculate on the outcome of this. So if there's no further discussion, the motion is to approve Ordinance 2207 on its first reading. All in favor say aye.
Aye.
Opposed?
No.
So noted. At this time, I'd request a brief break. I have a motion from council for a 5-minute recess.
So moved.
Second.
All in favor, aye?
Aye.
Aye.
Thank you. We're returning from our break. And moving on to item 3 on unfinished business.
Oh,
Motion to discuss.
Second. Okay, Mr. McClung.
I would like to suspend the rules and read ordinance number 2203 on its second reading by title only.
Second.
Very good. Mr. Mitchell, second.
Moving on.
This will require a roll call.
Yes.
James DeVito,
Yes.
Trey Seller,
yes.
Terry McClung,
Yes.
David Mitchell,
Yes.
D. Purkeypile,
Yes.
5-0. Ordinance 2203, an ordinance to amend Chapter 9 of the of the Eureka Springs Municipal Code, vacating streets and alleys.
Mr. McClung.
I'd like to make a motion that we pass ordinance number 2203 on its second reading.
Second.
Second. Any discussion? All in favor say aye.
Aye.
Aye. Opposed? Motion passes on its second reading. Okay, number 4, ordinance number 2201, Clean City amended version. Mr. Mitchell.
Motion to discuss.
Second.
I'm not too sure what we do after we've had one and we've read it and then we amend it. I don't know what we do with the amended version that's back in the packet. Do we start all over again, or
No.
what do we do?
No, you
We
would.
just accept it as it's in the.
If I'm correct, there would be a motion to approve the amended version.
Well, there's two ways you can do it. And one would be what Mr. Mitchell has just suggested, is you could actually give it a new ordinance number and just simply read it from the beginning. Or number 2, you can amend it, but you would need to read each of the amended sections into the record.
Lord.
Mr. McClung.
Couldn't we just, which would probably, couldn't we put it up for its second reading but not suspend the rules and read the whole thing as amended?
You could also do that as a proposed for amendment, yes. You could do that, yes. And then you would not have to read it what was being taken out that way. You would simply be reading what is new material in the normal stream of reading the whole ordinance.
Mr. Mitchell.
Problem with that is I don't think we have the ordinance with the strikeouts and everything. I think I have. We do have it. I'm sorry. I shouldn't think that way. We have that new one that's just doesn't show corrections in adds and deletions.
Correct.
So I guess
That I think is what Mr. McClung is suggesting, is just make a motion to amend it as to that reading, and then rather than do it by title only, read the entire document.
Mr.
And
Purkeypile.
that'll get all your new changes.
Okay. We don't have the final completed amended document in front of us or on the table. Correct?
Okay.
Isn't that correct?
Went
So
in the mailboxes today, UB4.
that's not the final.
I asked Mr. Mitchell to send it to me today. I cranked it out.
it's still got a red thing because I had a question to the attorney. Let's
On
clarify
page
this.
3.
Let me make a motion that we postpone this, table this until the next meeting.
Second.
Thank you. Second.
All in favor, say
Aye.
That's where I was headed.
That's what I thought.
All in favor, say aye.
Aye.
Aye. Okay, opposed?
It's just too much confusion.
Okay, so it's tabled till the next meeting. Thank you.
No,
This is going to be the one that's going to be
you have one that says UB4, and on the third page, there's a yellow line because of the question that Mr. Mitchell had.
Yes, if we
It's
can get it
in
with
the
the
mailbox.
corrected
Yes.
portion,
I
that
can
will
go back.
save us a lot of time.
Everybody got one in his or her mailbox, so
Correct.
that question could be answered this evening, so then it could be read. And third page, on the front it says UB4.
I'll get with the clerk and we'll have it corrected next time and we'll be ready to go. We'll roll.
Okay, very good, thank you. Moving right along, item number 7, under unfinished business, ordinance number 2204, reclaiming portion of Sweeney Avenue, second reading.
Motion to discuss.
Second.
I make a motion we suspend the rules and read ordinance number 2204 on its second reading by title only.
Do I have
Second.
Second? Any discussion? Okay, this will be a roll call vote. Madam Clerk?
When I was going over this and cleaning it up, I noticed there were two things about it. The ordinance title that was read had the wrong number, so I changed it. Everybody has a copy of, and I did put this in your boxes. It says UV7, the corrected version, and the version we read last time with the wrong title number. And the surveyor has provided a property description that reads pretty much in reverse of what was read at the table. It is not the same property description, so really it's not the same ordinance. You have two pieces of paper, they're clipped together. The one that was read, the one with the corrected number in the title, and the description provided by the surveyor late last week.
Mr. Attorney?
I would suggest that you approve it for its reading, then make a motion to amend it to those two changes, and then vote for approval or disapproval of the ordinance at that time. Because what we did, if you remember correctly, or if I remember correctly, at the last council meeting, we read it with the understanding that they were still working on the potential description, and this is the description that they have now provided the city. The other description was also, as I understand it, provided by them, but they preferred this description.
So we have a motion on the table to do this by title only. We can go ahead with that.
Read
And
it
then
by
come back
title,
and amend it.
and then read it with the old title, then amend the title itself, and amend the description itself before you vote for final approval of it on its reading.
Okay, we have a roll call vote.
David Mitchell,
Yes.
Terry McClung,
Yeah.
James DeVito,
Yes.
D. Purkeypile,
Yes.
Joyce Eller,
Yes.
5-0. All right, the old title was Ordinance 2204, an ordinance authorizing the City Council pursuant to Chapter 12.02.01E of the Municipal Code of the City of Eureka Springs, Arkansas, to reclaim jurisdiction over certain property commonly known as a part of Sweeney Alley.
Mr. Mitchell?
Now I can make the motion to amend the title of ordinance number
2204.
2204 and the content to reflect what has been presented tonight.
Yes.
Thank you.
Okay, I have a motion. Do I have a second?
Second.
Motion second. Any discussion?
It would be probably appropriate here if you did actually have the clerk read those two pieces.
Do I have to make a motion to do that too?
No, I believe your motion would cover that.
Yeah.
Okay.
All in favor, say aye.
Aye.
Okay, we'll have
Okay.
the clerk read that.
The revised title is just the number, an ordinance authorizing the City Council pursuant to Chapter 12.08.01E of the Municipal Code of the City of Eureka Springs, Arkansas, to reclaim jurisdiction over certain property commonly known as a part of Sweeney Alley. The description provided by the surveyor reads as, I'll borrow this, Sweeney Alley lying between Lot 6 and Lot 7 in Block 171 in the Riley and Armstrong survey to the City of Eureka Springs, Carroll County, Arkansas, and being more particularly described as follows: commence at the northwest corner of said Lot 7 for the point of beginning, then north 17 degrees 1 minute 42 seconds west 17.21 feet, then south 85 degrees 16 minutes 8 seconds east, 84.57 feet, thence south 7 degrees, 30 minutes, 34 seconds west, 16 feet, thence north 85 degrees, 16 feet, 8 minutes west, 77.41 feet, to the point of beginning containing 0.03 acres more or less.
Okay, question for the city attorney before we go any farther. If we approve this as amended, that still is the second reading?
Yes.
Okay. So we have read this, so I would seek a motion to...
Oh, I make a motion that
approve
we
it as amended.
approve ordinance 22-something,
2204.
2204 as amended.
Second.
Second. Any discussion? All in favor, say aye.
Aye.
Any opposed? Okay, that passes on its second reading. Okay. Item 8.